attorney and an authority on Asbury Park history. In January, when the developer inquired about a demolition permit for the casino, Tom published an article detailing that under the 2002 redevelopers agreement with Asbury Partners, or iStar, the city can sue for default and repurchase the casino, carousel, and power plant for $1.5 million plus hard costs. The city redevelopment attorney publicly disagreed, claiming a later 2010 agreement with Madison Marquette governs the casino, and said we can't take it back. The city then hired retired New Jersey Supreme Court Justice Lee A. Solomon to review the contracts and state which contracts govern the casino and whether the contract allows a lawsuit to retake it. Tom issued a 900-page legal brief and appendix and took part in a 2-hour oral argument before Justice Solomon and the city's attorney. Justice Solomon found that upon default, contracts do allow a lawsuit to reclaim the casino. However, and importantly, the city's press release reported incorrectly that Solomon found we cannot. Tom is here to discuss why and how the city's press release was so inaccurate and why they need to change it. And with that, I'll turn this over to Tom.
Thank you. I want to thank everybody for coming tonight, and I thank SOS-AP for having me. And before I get into the casino part, I want to remind everybody that Asbury Park has a number of really good historians out there. I enjoy them all. They write books. There's some that do tours. There's some that do articles. Others just do social media posts. But I hope you find them, enjoy them as much as I do. But there was always this one homegrown, strange historian that thought it would be a lot of fun to collect and save Asbury Park redevelopment contracts and documents. And that's how I ended up in this mess. And I'm here today with all of you. I drafted a slideshow to use with you today. As you can see, I chose, I'm sorry, it's going too fast for me here. I chose the Asbury Park School colors. It says Columbia, blue, and black. And this little guy on the screen, if you're wondering, that's our school mascot, the Blue Bishop. And while I love that guy, I'll be the first to tell you that he looks a little like the old cartoon character Ziggy, and he's very outdated. And we are a community of artists, and we pride ourselves on that. And I've always asked the artists to please hold a design contest to update our Blue Bishop, and I've been unpersuasive so far. So after you and I do the important work of saving the casino together, I'd ask you to join me in convincing the artists to update our Blue Bishop. Now, this speech I'm going to give you is long because it has to be. It's going to be about 30 minutes. It is a 44-year evolving fact pattern, so there's no way to do this shorter, so I apologize up front for that. But when you have a long story, you want to tell the final part up front, because it makes it much easier for everyone to follow the story if they know the final part that's coming. So let's jump right into that. Why did the city press release misstate Solomon's decision so badly? And to really understand that, this first part, and I know some of you are on small screens, so if you can't see my slide, I will either read or paraphrase for you as I go along. The first important point we have to remember is something Solomon was asked to do. He was told to assume the developer is in default and then look at the contracts and say, what can we do about that? He was not asked to say what the defaults are. He's not asked to go out and look at the evidence and find them. Just assume they defaulted. What can we do about it? So after Solomon assumed the default, he found that contracts do allow a lawsuit to repurchase the casino. Then the city seems to have made a dreadful mistake. Like Solomon assumed there was a default and said we can sue, the city, whoever wrote their press release, assumed there was not a default, and they didn't look at contracts. They didn't look at the subsequent proceedings. They didn't look at any of the reports. They simply assumed wrongly that there was no default. And think about it. If there was no default, why would you hire Solomon in the first place? Anybody could say if there's no default, you can't sue. So why they assumed a default without looking, we may never know. But that's what happened. And that's why their press release was so bad. And what our goal here today, what I'm trying to get them to do is correct that press release so everybody's on the same page and we can all move forward. Um, Now, this next slide, before I get to it, it probably has the longest introduction. Um, the reason why there was such a misunderstanding for so long in Asbury Park is we had our very own Mandela effect. And I'm sure a lot of you already know what that is. That's when a society misremembers something from the past. They're so sure they remembered a certain way, but then when they dive into it and do the research, they find out, wow, we were wrong the whole time. And here's Asbury's Mandela effect. In 2002, we signed a contract with Asbury Partners to redevelop every building on the boardwalk. That includes all of them. But then in 2010, we entered into a subsequent developer agreement with Madison Marquette, and everybody thought all the buildings from the 2002 contract went into the 2010 contract. The 2002 was now gone. Everybody thought this. The populace, the greater area, all of the media, everybody believed all the buildings went in the new contract, except one homegrown strange historian who eloquently said, "Nuh-uh, the casino stayed back in the 2002 document. It's the only one to do that." Dan Jacobson of the Tri-City News was so sure that I was wrong about that, that he bet me lunch at Frank's Deli. He said, Justice Solomon is going to find right up front in a short report that the casino is not in the 2002 agreement, it's in the 2010. So let's look at the next slide and see who won the bet. Which agreement governs? Justice Solomon on April 23rd said, unlike Convention Hall, the obligation to redevelop the casino remains with Asbury Partners under the 2002 agreement. Now, all of you know how fantastic the pork roll, egg, and cheese is at Frank's Deli, but it tastes a little bit better when Dan Jacobson has to pay for it. And he did. So that's half the battle right there. We now know that the casino is in the 2002 agreement. So what does it say? Does it say we can sue upon a default to take the casino back? Let's see what Justice Solomon said. He said on April 23rd, same report, Asbury Partners would be liable for any default in the redevelopment of the casino, and the city's remedies would be governed by the 2002 agreement. These remedies may include repurchase of the casino. That's the question we wanted answered. That's why Solomon was hired, and he answered it right there in his first report. Okay, and we've now got this this huge weapon against the developer that we didn't know that we had before. It's time to publish this report, pop the champagne, call the developer, and say, you got to move because we've got this gun. We can take the casino from you now. Suddenly, for some reason, somebody at City Hall, and we don't know who, started to act weird. Somebody didn't want this report published. So they asked Justice Solomon a question. You don't know what that question is because you weren't told, and I don't know what it is because I wasn't told. But we know someone asked him something because he answered, and he answered in our next slide on April 28th. This is a week after the first report. This on the screen is the entirety of what his second report was. It's just one paragraph. And I'll give you the end part up front. He says nothing has changed from his previous report. I'll read a little bit of it. He says the scope of our report was an analysis of the remedies available to the city in the event of default. Yeah, we know that. That's what we asked you to do. Then he adds two things that he said he didn't talk about in the first report. And of course he didn't, because he wasn't paid to do this. These would be big jobs. He says he did not talk about what the likelihood of us succeeding in the lawsuit would be. Well, of course not, because he's assuming a default. To figure out the likelihood of success, you'd have to look at the default and see how strong it is. So he said, I didn't say either way. I didn't say you'd win. I didn't say you'd lose. Then the other part is the cost. Well, again, he's not looking for the defaults. That might take some time, effort, money. So he's saying, I don't know what this will cost. That's up to you guys. And then he ends this little letter. Once again, it's time to publish these letters, pop the champagne, and call the developer and say, you got to move. But that didn't happen. And the city got even more weird after this. Instead of publishing these reports, the city attorney announced that he was going to redact the reports. That I can't say I understand that. You're telling me you're going to redact a Supreme Court justice's opinion? And I don't know if these folks at City Hall have followed the news for the past year, but when a government says we're going to redact a document before showing it to the public, it doesn't generate much trust. But that's what he said he was going to do. And they did something else at this point. Despite my initial letters in the media being the impetus for this, despite me doing a 900-page brief and appendix, despite my 2-hour cross-examination by Judge Solomon, somebody at City Hall decided I'm out of this. They're not gonna let me be a part of whatever it is they do after this. They didn't tell me I was out. I didn't find out till later because I didn't know what they were doing in the background. But we got to take a look at what they did in the background. What they did in the background was somebody sent Justice Solomon a third document to look at. It's a contract. It's called the 2006 Dispute Resolution Agreement. Well, first, let me talk to you about what that is and how it came about. It is a contract, and here's how it came about. After we signed that contract in 2002 with the developer to develop the boardwalk buildings, for 3 years, the developer never touched those boardwalk buildings. I'm shocked, I tell you. But the city came to them and said, look, we've got environmental problems there that you were supposed to clean up. That's dangerous. The roofs are leaking. That's accelerating the dilapidation. We need you to do these emergent repairs right now. And here's a punch list for each building. And the punch list for the casino was $1.3 million in repairs. What they did was they signed this contract to govern itself. It does not touch the 2002 obligations. We don't know what the city asked Justice Solomon about this, but I think from looking at it, they asked him, does this 2006 agreement and this $1.3 million in repairs remove all obligations from the 2002? And before Justice Solomon gave his opinion on that, I think he trolled the city a little bit, because in the beginning of his report, he cited the 2006 contract language, and I have it in yellow here. He said, oops, and of course it goes away when I got to read it. Okay, he says the 2006 agreement explicitly states that projects other than those listed in the 2006 shall remain governed by the dispute provisions set forth in the 2002. The contract literally answers the question. This does not vitiate the 2002. 2002 is still there, but they paid him for an opinion, so I don't blame him. He gave an opinion. Let's look at what he said. Justice Solomon said a month later on May 28, the remaining Asbury Partners' remaining development obligations, if any, would only be those that were provided under the 2002 agreement, but that were not listed as projects under the 2006 agreement and therefore were not subsumed. That sounds a little legalistic, so he followed it up in the next sentence quite clearly. If there are any remaining redevelopment obligations of Asbury Partners regarding the casino, remedies for default would be governed by the 2002 agreement. Yeah, that's what the document says. This is not canceled the 2002. Other than those $1.3 million in repairs, if they didn't do any other repairs, you can sue them for those. Once again, publish this, pop the champagne, call the developer, tell them to move out. We're at that point at this moment. But Justice Solomon reminded us of something that we talked about in the beginning of my talk here, that he's only assuming the defaults. If there are any, it's up to us to go find them. And I don't believe the city ever looked. But Justice Solomon said, it is beyond the scope of this letter to evaluate whether such obligations remain and whether there has been a default with respect to any such obligations. So he's reminding us he's not going to assume them, or he's assumed the defaults, but if they're real, you got to go find them. So to be fair to the city, I'm putting up this slide to see what they said in what they published, because they didn't just publish Solomon's decisions. They had their own attorney do a memo of what he thinks it said, and then did the press release based upon their attorney's memo, not what Judge Solomon said. So and what they did in the memo was they simply, just like Solomon assumed there's a default, they assumed there's none without looking. And they wrote this letter, this sentence. And this is from the city redevelopment attorney's memo. Justice Solomon stated in the addendum that the 2006 DRA severely limits and potentially eliminates Asbury Partners obligations. Do you see the words 2002 in there? No, because Justice Solomon was talking about the $1.3 million from the 2006. It severely limits our rights to do that because that work was done. We admitted it was done. This says nothing about the 2002 agreement. How do I know that the city attorney didn't look for defaults? Well, the next part of his memo, and he underlined this stuff. That's why I underlined it. He says, and look at the first 6 words, without a remaining Asbury Partners obligation. There cannot be a breach by Asbury Partners. Without a breach by Asbury Partners, there cannot be a take-back remedy. Yeah, without a remaining Asbury Partners obligation. That's what he didn't look for. So he just assumed there were none. I don't know that he knew there were any. This is the part where I'm going to ask you to judge me, because I'm going to show you right now that there most certainly were obligations, that the city has all these documents because I got them from them years ago, but I do have them. And these documents show the obligation and the default. So I'm going to show you an obligation, I have to start with the contract itself. Section 3.5 of the contract, you're going to hear a lot about this, is where you list what the construction obligations are. Now, construction obligations tend to be lengthy, so it's typical for contracts to not include the words in there. They say we refer to another document. So let's read what the construction obligation of Asbury Partners is. They're called the master developer in the contracts. The master developer shall have prepared a report by a professional firm. Now, let me stop. It says 3 things this report has to have, so keep them in mind. This report has to have recommendations on rehabilitation. That's construction. It has to have the costs of it, and it has to have a detailed schedule of when these renovations are going to be done. That's the report they got to give to the city. The next paragraph, and I put the parts in red because we're going to continually go back for them, that important. It says the parties shall, within 120 days of getting this report and prior to closing. That's the contract saying to the city, don't close unless you do this. Prior to closing, they will agree to a schedule of renovations to be undertaken by the master developer after closing. Not a suggestion, not if you feel like it, not a maybe. To be undertaken. So the question then becomes, was there such a report with these 3 things in it that the city accepted? Well, as they say in the Midwest, you betcha. And I'll show them to you now. This is the Clark Caton Hints report. The developer gave this to the city in 2004. And let's see if those 3 things are in there. 1, it is 300 pages of detailed construction plans. The cost is $33.6 million, and that's $59 million in today's dollars. The schedule for construction is 2004 to 2007. That's long enough to do that because the Empire State Building was built in 13 months. The city, this is important, the city then closed on this 62 days later. They closed on the casino and sold it to the developer. Government never moves that fast. But I have to remind you of the prior slide. The contract said they have 120 days to do it. That's why they did it in 62. Game over. We've got the construction obligation. We know that they didn't do them by the condition of the casino. Let's call the developer, tell them to move. Instead, the city had questions for me. And the first question was, okay, Tom, how do we know this Clark report is the report that 3.5 is talking about? So to answer that question, I referred them to the introduction of the report, which says, this report has been prepared in response to a requirement in section 3.5 of the contract. Are we good? Because it says right there, this is the report, and we know they didn't do it. But the city had another question for me. They said, okay, and it's almost as if somebody down there doesn't want us to win. The city said, okay, Tom, prove to us, show us one piece of proof that the city really accepted this as the contract of repairs. Just one piece of proof. And my response was, I'm sorry, that's the wrong slide there. My response was that I'm going to show you 5 pieces of proof that you guys accepted this. And the first proof that shows that the city accepted this Clark Keaton report was that the contract itself is self-executing. And in the law, that means once you satisfy something, an action, you don't need to say that you did it. It's self-executing. It's automatic. This said the renovations, once you close, was to be undertaken. Now you guys have to put your judges' hats on here. To be undertaken. If that's clear, a judge will say, I'm enforcing that. You were supposed to undertake these. If those words are not clear, a judge can then say, show me extraneous evidence, show me outside the contract evidence that proves this is an obligation. I think sitting here from having practiced for a long time, but I think you, even if you're not lawyers, can determine to be undertaken is pretty clear. What could it possibly else could it mean? Could it mean not to be undertaken? No, it says to be undertaken, and that should be enough to satisfy the city. But let's give them more. They want to know, did they ever accept the Clark report? I'm going to take you to number 2. On December 17, 2004, this is 2 months after getting the Clark report, the city, of course, has to do a city council meeting where they authorize the city attorney to close on the casino. And that night, people were complaining about the low price we were selling it for. This is the casino, the carousel, and the heating plant for $1.5 million. Now, this is extremely important. Jim Aaron was the city attorney at the time. He put this into the record, and I'll read it. Aaron said the cost for the casino was struck because of the substantial cost to remediate environmental problems and then rehabilitate the casino. Listen to this. A new report from Asbury Partners estimated a cost of $33 million to be borne by the new owner to renovate the building. Case closed. In legal terms, what they just did there was admitted to a quid pro quo. That's required for a contract to be valid. Each side has to give something up. What Jim Aaron just said there was that the developer said to us, lower your price and we'll do the $33 million in repair. And we said, okay, we'll lower the price. You do the $33 million in repair. And then they closed. So we accepted it on that night. Is there any other proof we accepted it? Let's go to the fact that they did close under the law is called assent by action. One way to accept a contract is if a person says to you, here's a contract I want you to do. You don't have to write, I hereby accept the contract. If you perform the contract and finish it, you accepted the contract. Under the law, performing a contract is, of course, accepting the contract. So when they closed, they accepted the Clark report because the contract said don't close until you do it. That should be enough, but let's give them more. They put section 3.5, the obligation to repair, and article 8, that's the defaults into the contract. They took those words and they typed them into the deed. And then they filed together, the city and the developer filed this deed with the county. And what that does is, I'm sure you've all heard this expression before, that makes the obligations, quote, run with the land. What does that mean? That means any subsequent purchaser, like Madison Marquette, if you're a subsequent purchaser, you're on notice, you have to do these repairs. This is quite clearly, we have accepted the Clark report as part of our agreement. There is another area of proof that is so important, and it's not just important for this part that I'm talking about. You can see it runs through a lot of what happened here. It's so important it gets its own slide. So let's look at it. And this is shocking. This is a shocking part you're about to hear. Remember the whole 2006 agreement that they had Judge Solomon look at? Well, it was amended by contract by all the parties, this time including Madison Marquette was the signatory as well. City, Asbury Partners, and Madison Marquette amended the 2006 contract with a 2007 amendment. Why did you send Justice Solomon the 2006 contract, but not send him the 2007 amendment? That's like sending the man half a contract, which is what they did. Why did this contract come about? Yeah, the why is always important. Well, Madison Marquette came around 2007 and said, we want to buy these buildings now, even though, they didn't get into their actual development contract until 2010. They said, we'll buy these now, but we want assurances from the city that if we buy these buildings now, we don't inherit the defaults of you know who. Please promise not to default us until we get into a subsequent agreement to repair these buildings. And the city said yes and signed this contract. What's interesting is something we already know from Justice Solomon. Solomon said there is no subsequent agreement ever made for the casino. That's why he said the casino isn't the 2010. If they had made an agreement like they did the rest of the buildings, Solomon would have said, okay, yeah, it's in the 2010. You're out, Tom. But Solomon found no agreement for 2010. They completely carved out the casino and said that doesn't go into 2010. So there's no subsequent developer agreement. Now, this is where it really gets more interesting. This 2007 contract that they all signed recites the Clark Caton Hints obligations to develop the casino in it. It has the three-story building they're gonna build on the site where the arena was. It has a redevelopment of the arcade that you walk through. It has businesses that are going to go in the other building, businesses that are going to go in the carousel. All of it's going to be redeveloped. Put it in the Clark report in 2000. Put it in the contract in 2007. Now, this ends it. This contract literally says, signed by all three of them, it literally says, Asbury Partners shall remain responsible for that work. I put it in red. The 2007 contract says Asbury Partners shall remain responsible. They didn't send this to Justice Solomon. I don't know why, but I know it was a really important document that they sent it. And had they not fired the historian from the proceedings, when they sent it to him, I'm sure it went by email, I would have done a follow-up email and said, oh, don't forget the other half of the contract. It's the 2007 contract, all he signed. We don't know why they decided to do that, but I think it's game over. I think it's clearly we've established that there is an obligation and we know they defaulted. One quick aside about the abandonment clause. Solomon didn't talk about this because remember, he was asked to assume the defaults. The abandonment clause says we can take the casino back if the developer doesn't diligently prosecute the project. Well, they bought it 24 years ago, and all we got so far was a request for a demolition permit. But here's the scary part. This is a 30-year plan, and it expires in 2032. There's something in the law called the doctrine of latches. If we file suit after 2032, we risk a judge saying, you let the plan expire, Asbury Park, you let your rights expire. So it's an emergency to do this now. We only have 6 years left. So to wrap this up, to look at why was the city so wrong in the press release, in his I want you to judge this. You folks looking in, tell me if Mr. Mariziti or whoever drafted this was stating this right. Mariziti claims in his memo, Justice Solomon and I are in agreement. The effect of the dispute resolution agreement on the inability of the city to take back the casino buildings. Did you hear Justice Solomon say the contracts show an inability to do this? No, he said repeatedly, you guys find the default, you can do it. And I think today we've made a pretty strong case that that default exists. Then they said, and don't blame John Moore, the mayor, for this, because mayors who are not lawyers or get told by lawyers, this is what we're putting in the press release. Trust us. He's not going to run to law school for 3 years and come back and say, okay, he's got to trust them. This has John Moore saying, while the report confirms that reclaiming ownership of the casino is not a viable path under the existing agreements. Is that what Justice Solomon said? No viable path? Throw these reports through AI and see if you can find the words. He definitely said we have a way forward if we find the defaults, and not to beat a dead horse, but I think we really did. What am I looking for from here? I don't want blame. I don't care who was wrong, who over misspoke, didn't have a document, misinterpreted a document. I want the city to just correct the press release that says, considering these other documents, it's clear Justice Solomon said we could retake the casino upon a default. And then I want all of you, the football gets handed off to the public at that point. You've got to then have a conversation with your mayor and council on whether you want to go forward with this lawsuit. There's other issues to be talked about that's beyond what we're talking about today, for sure. But I want you in that position on July 8th. I don't care if my name never comes up again. You guys deserve the right to be in the position to have a correct release and to talk to your mayor and council about filing this lawsuit. That's all I have. I hope you enjoyed it, and I'm going to turn you back over to SOS at this point.
Thank you so much, Tom. That was really very insightful. And I know that this is very complicated. You've got a request for a ham sandwich, Tom. But there's a couple of comments that we'd like to just jump right into. There were several remarks in the Q&A regarding attorney Joseph Mariziti. He's the city's redevelopment attorney, for those of you who are not familiar. How long has the city had the same redevelopment attorney or firm? And shouldn't they know this information inside and out?
That's for me.
Yeah, that's for you.
I think they've been around about 10 years, and yes, they should know all of it.
Okay. Do we know if, and for those of you who may not have asked a question yet, please put your questions in the Q&A and we'll try to get to as many as we can. Do we know if and how much of the 33 million in repairs of the casino was ever completed?
My guess would be none of it, but if any, I mean, just look at it. My guess would be none of it, but they might be able to make a case where they did, 200,000, even if it's a million, we got to add that to the 1,500,000 when we buy it back. I'm not concerned about the 1,500,000 to buy it back because we have condos across the street selling for $9 million. I'm pretty sure the city can get a pretty penny for what's there from another developer.
Okay. We took a look at a parcel of land up the block from where the casino is, and granted, it's a different use. It's residential, but we understand. I think it was the Triangle parcel, went for $10 million back in 2021. So it may not be an apples to apples comparison, but it's an interesting point of reference.
Yeah.
We have another question for you. If Asbury Partners is in bankruptcy, what relief might reasonably be found by suing them? And thank you for all your hard work on this.
And thank you for saying that. Yeah, if they were to file for bankruptcy, that's always a possibility. And of course, Asbury Partners, and a lot of people don't know this, but Madison Marquette set up a company to own all these boardwalk buildings, and Asbury Partners owns 50% of that company. So they're in bed together. It's very incestuous. So if they were to file for bankruptcy, we run the risk of having to, like last time, like in the 90s, wait out the bankruptcy. But that's not a reason to go forward. anybody in the world you ever sue, every case I've ever filed, there's a risk the other guy might go bankrupt. That's never a reason not to do it.
Thanks. Okay, Tom. Another one. Has the city said explicitly that they disagree with your assessment? If so, have they explained why? And have you countered that position? There's still
Um,
another question. Still another question.
oh, sure.
Can Solomon not be contacted to clarify any differences in interpretation?
All great questions. Since issuing the flawed press release, the city has said nothing else. So they've not responded to anything more that I've said. They've not explained themselves. And as one reporter pointed out to me, at least I'm always pointing people back to the contract when I give my assessment. They never have done that. They say, "Well, this is the way it is. Believe us," and they don't cite the contract. As so, I don't know if they're ever going to put out a statement. We're hoping in July 8th that they do, and we're hoping that at least I get a chance to respond that night so we can have a real debate about it. They're likely to give me just 3 minutes at the microphone, but I've asked them for more if they're going to make a presentation. As for Justice Solomon, that's an interesting question. Um, if you check him out, he's a heavyweight in New Jersey law. And I certainly asked around about him. And what I found was he is also the most polite, collegial, personally likable guy. I have emailed him twice in the past 10 days asking, hey, we've got this big problem in Asbury. We're fighting over what you said. Can you please give us an update that clarifies this? This very polite man so far has ignored me for 10 days. And I think we have to keep in mind he's paid by the city. It's not unlikely that after receiving my emails for a clarification, he got on the phone with Asbury and said, should I do this? And they said, no, they don't want it clarified. And that's going to be my story until I hear from the city otherwise, because I sent 2 emails to this judge and he won't answer me.
Okay. Quick one. Does a person need to be an Asbury Park resident to fight this?
No, absolutely not. The more the merrier, the more people we can get on our side. Asbury Park is a regional attraction. And in a sense, I want you to think of it as your own. I don't care if you live 200, 300 miles from here. It's part of who you are. So feel free to jump in this fight.
Um, Similarly, in that same vein, if a lawsuit is required to regain the property, who files the suit and who funds it?
The city files the suit. They're the only ones that can, because they're the only ones with what's called standing. And it is the taxpayers who would have to fund it. Now, there are groups that have offered, financial help, and if they want to, they can. But you can't count on that. It's ultimately always the city's responsibility. So that's why I said you want to have a conversation with your city whether you want to do that. Figure out what it's going to cost, compare it to what you might be able to sell it for. If you can sell it for $10 million, who cares if you spend $300,000 on a lawsuit? You're going to make a lot of money when you do. So, but those discussions have to be had between the people and their city council.
Okay, I've got another one. Just want to mention there is, uppercase IS, a developer willing to buy all of these historic buildings and restore them themselves. So the narrative that the city seems to be pushing, that Asbury Partners, MM, etc., our only hope is completely a lie. Happy to discuss that further. That's a
Yeah,
statement.
and I'll add something to that, something to say I think they could be doing. And this wasn't my idea. I'm not that smart. This happened 30 years ago when we were discussing this plan. The city can host a design contest and put out to the world, hey, look at this project. Why don't you tell us a design contest? What would you be willing to pay? And give us some sketches of what you might want to do to it. And that was bandied about the first time we did this. And that's a good idea because you get some free information. You get some information about people might want to be pay, who might want to be interested, and what they might want to do. And it's all free. So that'd be my suggestion is hold that design contest. Let these developers that we have know that we're moving on. But I appreciate the comment that there are people who are excited about coming in. A lot of people have gotten calls from folks inquiring if they can come in now.
I've got another one for you. There was a roof statement. There was a roof repair after 2002. Having worked on dozens of similar historic buildings through the country, looking at the casino arcade, the structural steel will need to be replaced. Is there a requirement beyond the 2002 agreement which requires the developer to replace the structure they demolish with an identical replacement?
Okay. I always want to stay in my lane, and how construction gets done is way outside of my area. But from the legal perspective, the requirement is that you redevelop it. What that looks like is probably in the Clark report. If it's not, it's still something they have to do. And you would want to address that to somebody like the person answering the question who's in that business, who could then tell us, this needs to be done. But that's putting the cart before the horse. First, we got to get them to the point where they know they have to do this.
Okay. Next question. Why is correcting the press release so important? Can't the facts be recorded as they are and as you have stated, an agreement to continue the conversation and take action with these facts?
Great question. To me, it's important because it's a conversation ender. As long as that press release is out there, that's still their official position is that Judge Solomon said there's nothing we can do. So as long as that's their official position, they will not be having that conversation with you going forward. They need to correct the record on where they stand. Right now, they stand on Solomon having said the contracts give us no rights, and that's just not what they say.
Thank you. Another one. If there are 6 years remaining on the 2002 agreement, why is it important for the city to pursue a lawsuit now?
Okay. The well, first of all, we gotta adjust our terms a little bit. There's not 6 years left on the agreement. There's 6 years left on the waterfront redevelopment plan that the agreement is subject to. And there's a lot of things in law that lawyers and litigants don't know the answer to until they get to the judge. Only the judge, who has yet to hear a case, knows the answer. This is one of those times because the doctrine of latches that I talked about is not a legal principle, it's an equitable principle. It's something that a judge does says, okay, this isn't in writing anywhere, but I think the parties are disadvantaged by what happened, and I'm allowed to um, put forth this idea that's not in your contracts, it's in the law, this doctrine of latches. My fear is, and I don't know that it's certain, my fear is the judges, if we let the 2032 plan expire, the judge is going to say, you let your plan expire. The contracts were pursuant to plan. You have no more plan. You have no more rights under the contract. I'm not saying that's a definite, but when you're a lawyer and you're advising a client, you got to tell them what might happen. So the answer is don't let it happen. Don't get to 2032. File this suit before then. That way it can't happen.
You got a bunch more questions coming. Um, what actions can the community take now before the July 8 meeting to ensure an outcome that thoroughly addresses your concern during that council meeting?
Yeah. Well, I'm going to defer to SOS on this because they're the community activists here. They're the ones with the experience, and they're going to tell you there's letter writing campaigns, call the city council if you want to stage a protest, all sorts of things, but they're better on what political activism you can do between now and then, and you should do it.
And I just want to acknowledge that we've gotten a flood of questions in the last few minutes, and so I'm trying to answer them in order and as quickly as I can. I'm grouping some together. Um, can residents try to contact Justice Solomon asking for a clarifying statement from him? Strengthen numbers? Question mark.
Um, I'm afraid to say yes to that because I don't want the guy harassed. He didn't do
Yeah.
anything wrong here. He certainly did what they asked of him. They said, limit yourself to these documents. That's what he did. He issued three reports. He got paid for those. I would hope that he wouldn't have to suffer through a bunch of emails, people asking him. He certainly knows on your behalf. I asked him. I have two emails floating out. He knows we want this. Two emails floating out there to him. He knows we want this. It's on his radar. I don't know that a bunch of more emails are going to help our cause. I would hope that you wouldn't, but I don't control you. So, you're going to have to make your own decision on there. But I do think I wish that you wouldn't.
Okay. I'm not a
Oh,
New
wait,
Jersey.
I'm sorry, let me add to that.
Go ahead.
Definitely flood the city council with all your requests. It says you authorized Justice Solomon to make a report. That's where you want to do that. Flood them with that request.
The next question we have is, I'm not a New Jersey resident, but go to AP a few times a year. I spoke to two shop owners last time I was there. I was told that the city doesn't really want the casino or convention hall to actually be rehabbed. They want it to be demolished so they can gain a larger tax base through the building of a condo tower on the site. Thoughts?
Um, I, I, I'm not, I don't speak for the city council, obviously, but we're trying to read the tea leaves here. If the city didn't want to do this lawsuit, if somebody on the city council, or at least three of them on the city council, didn't want to, they never would have hired Justice Solomon to find out if we could. They could have easily said, after my columns came out and their lawyer said Tom's wrong, they could have said, sorry, Tom, our lawyer says you're wrong, and moved on. So the fact that they hired Solomon tells me they're being open-minded on the possibility that we can go forward. And right now, we've got New Jersey something called the CAFRA Act, and there's a whole government department that runs it. It would be really hard to build condos on the beach. They usually don't allow that anymore. I'm not saying impossible, but really hard. I doubt that that's anybody on the city council's plan. I don't speak for them, though. I'd ask each one of them individually.
Okay. And there was a question about who purchased the triangle. um, a APW Redevelopment, an affiliate of Asbury Partners. And I see there was a question about riparian rights, which are relevant to purchasing property near water. But I'm told, not an expert, that they are not relevant. And I've got gobs more questions. Has there been any conversation with the mayor, city council, city's lawyer since the press release and subsequent press on the matter? Over to
You
you,
mean
Tom.
with their own lawyer?
With the cities, this does not stipulate which attorney they mean. I presume it's the redevelopment attorney, Mr. Mariziti, but it says the city's lawyer since the press release and subsequent press on the
Oh,
matter.
I would imagine they're all talking to each other behind the scenes a lot, but I'm not privy to any of it. I got removed from the process before they sent out the 2006, but I would imagine they're all talking to each other. And both city lawyers, I mean, we do have a redevelopment attorney as opposed to the city attorney, but they were both involved here. You notice Justice Solomon's letters were addressed to the city attorney, not the redevelopment attorney. So they're both involved, but I don't know what communications they're having with their own city council. I would imagine a lot.
Okay, we've got 6 minutes left, and I'm going to try and whip through as many of these as possible. Is the language that describes a takeover for default on rehab, etc., in detail, or how do you characterize them?
Well, the language, you mean the default language itself?
I think that's what's meant here.
Okay. Yeah, the default language itself. See, the reason why we're fortunate that the casinos in the 2002 default language is much stronger than the 2010. You're going to have a more difficult time with the rest of the buildings. I hate to inform you, and Justice Solomon talked about that, but it's much stronger than the 2002 with the casino. We've got a real chance of taking this back. So, by the way, recapturing the casino was just one of the listed items you can do. There was take away the redevelopment rights. There was sue them for money. There was a bunch of different things you can do. So it's pretty strong. Going back to the first redevelopment contract, because this business started when I was in high school, by the way, senior citizen now. We started in 2002, this project. We had a prior redevelopment contract, a whole different company, a whole different agreement. That language said if they default, we don't even have to go to court. We could just walk in and kick them out and file a deed. I wish we had that, but at least the 2002 is strong enough that we can take the casino back.
Okay. Next one. Tom, please talk about the ability to sue for default. Gives us leverage to reach a resolution.
Yes, one of the things, and if you're reading all the newspaper coverage about this, that's Dan Jacobson's position is, well, now we've got this gun that I talked about that we have now, this ability to do this we didn't heretofore know we had. Dan is of the opinion, hey, we take that to this developer and renegotiate and don't file suit, get them to the table to talk about renegotiating all of this. That's one way to do it. My preferred way is you file suit and wait for them to call you to negotiate. Because the first way, you're coming at them from a position of weakness. It's almost you're saying, we're not that sure we want to do this. I'd rather file the suit and let them call us. That's coming from a position of strength. Just my thought. That's not an answer that you have to go with. You can certainly think Dan's way is better.
If there is some question that Asbury Partners may be responsible for the casino, one thing we can do is make sure that the city council doesn't approve any more condo projects for Asbury Partners until we have clarity on those issues. We are handing AP money with one hand while watching the historic buildings fall apart. Statement, not a question.
Yeah, there's some issues there. Some of it out of my lane. I'm a litigator. I sue. So that's the area of law that I know. What you're talking about is land use law, and the little bit I do know about it is normally if somebody's in default on one project, you can't hold that against them on another project unless the city passed an ordinance that says you can do that with taxes. If you owe taxes on one property, we're not going to let you redevelop another. But that's a maybe for me. I'm trying to be as helpful as I can with my answers, put a star next to that one. I think that's the case that you can't hold one against the other, but ask more lawyers, do more research on that. That's just my thought, but it's out of my lane.
Okay. Somebody wrote bingo, file, and then have a chat. Can the casino default be leveraged to the address and or reclaim the rest of the boardwalk?
Now, again, these are my opinions. I don't want to be sitting up here like I'm the all-knowing, all-seeing best lawyer in the world. I'm the only reason why I'm here is because I had this weird situation where I knew the whole history of this, so I was able to figure this stuff out before anybody else. From my understanding, what Justice Solomon wrote is the rest of the boardwalk buildings are not under the 2002, and they don't give take back rights really. But I have not looked at these contracts from the point of view of what can we do about this building, that building, this building, other than the casino and the Sunset Pavilion. I could say we're allowed to do with that, but the rest of them I've not really researched. And I hate to be disappointing. I hate not answering questions, but Justice Solomon did talk about it. So pull up his April 28 report and see what he says.
A couple more questions. I think we're getting close to the wire here. Any talk about adding a fee to tickets sold on events and AP to help fund preservation? See here now, $5 per ticket. Mentioned it 2 years ago. How do we get this started?
That's a political question, and I'm no politician.
Fair. Okay. Solomon did say if you can prove a joint venture between MM and partners, I think you may be able to rescind their rights.
Oh, it's not a matter of proving it. It's absolute. In their founding documents, they say that they are a joint venture. And then in the 2002 redevelopment agreement with Madison Marquette and the city, the first thing it says up front is that Asbury Partners and Madison Marquette have formed a joint venture. So that's not even an issue. We don't have to prove it. They admit it. But that doesn't really change our rights. That just changes who to sue, not really what you can sue for.
One more question. Can repairs be undertaken by the city and charged back to the developer?
Not that I'm aware of, but I didn't look into that, but I don't think so.
Okay. I'm going to have to pause here because we are at the 7 o'clock hour, folks. For those of you who are wondering, what you can do next if you're feeling like you want to do something. We encourage everyone to please attend the 7/8 meeting of the City Council. That's at City Hall at 6 p.m. Bring a friend, bring your thoughts, and if you need help forming thoughts or formulating questions, we'll be happy to help. We do have on our website, which is www.sos-ap.org, prefab letters that you can send to the City Council. We do encourage you to please write to them and express your feelings about the casino and that you want it to be preserved. If you have any questions that we were not able to get to after the webinar, no worries. Email us at info@sos-ap.org. You can also visit our website for updates. We have a newsroom that we're updating regularly as the story continues to unfold. And things don't stop after July 8th. The council meetings are vital. Planning board meetings are vital. The schedules are online. If you can't attend in person, please watch them. Really interesting things are happening at these meetings, and they're definitely pertinent to the future of our city. I want to thank everybody who attended tonight, and we thank you so much for your support. Tom, again, amazing work. Thank you so much for all you do for the city.
Thank you
Can't
for
thank
having
you
me.
enough. I think canonization is appropriate in this case. And we'll be looking forward to seeing everybody at the 7/8 meeting. Thanks so much.
Thank you.